Good morning and good afternoon, everyone. My name is Safak Herdem, and today we are with two guests to discuss the third country's G7 sanctions, decoupling risk and streamlining compliance. One is Bohdan, the other one is the Darya, and I would like to thank to them to their participation in this valuable discussion. We will almost have 45 or 1 hour in discussion on these issues, and you can drop your questions in the Q&A box whenever you feel that you are ready to ask the question. And I will ask my colleagues to introduce themselves. Bohdan.
Yeah, hi everyone. I am Bernatskyi, research fellow at the European University Institute. My primary field of expertise is sanctions, and I'm glad to meet you all and pass the floor to Darya, to my colleague.
Yes, hi there. First of all, thank you very much for having us today. My name is Darya Kuzmina, and I am head of sanction department at StateWatch think tank. We are Kyiv-based think tank who works on sanction evasions. Thank you.
Perfect. Thank you very much. I think let's start with Bohdan, and he will give some brief and general information about the sanctions and the sanctions world and what he faces actually. Please go ahead, Bohdan.
Yes, so the idea of our project is, let's say, to familiarize the practitioners in the third countries with the sanctions tools, sanctions compliance, and to get to know how actually sanctions work in jurisdictions which not legally, but still obliged to comply with sanctions. As you might see, many new instruments have been introduced, especially in the European Union, with regard to combating circumvention schemes and evasion networks. And this is not, let's say, question anymore whether a country in question comply with G7 sanctions, but it is rather a harsh reality that non-compliance with G7 sanctions can lead to very serious and severe consequences, which actually will be resulted that your business ended, you will be denied to make transactions in dollars and euro, travel access and admission to European Union, United States, United Kingdom may be denied. So many other serious, especially reputational risks might arise from the non-compliance. That's why the compliance with sanctions, and yeah, I think Safak is the best who knows locally why is it important even to follow in the jurisdictions which not legally joined the G7 sanctions against Russia, against Belarus. And even we can see that North Korea face the same autonomous sanctions from G7 countries. It's not only the case where we have United Nations Security Council sanctions, it's already there that we might observe in the future that autonomous sanctions regime will play more and more important role. That said, we can jump into the structure in the sanctions, and why it's important to start from here that the sanctions infrastructure, while we have joint aim stated in the G7 official communication, we might see that sanctions infrastructure in the European Union, in the United States, in the United Kingdom is completely different. And the way how sanctions crafted, the way how they organized, making it even more complicated for practitioners in certain countries to follow. And we can start here from the United States, which is probably the most active, or someone would call the most aggressive jurisdictions in terms of compliance with sanctions. During previous administration, and now we have, let's say, the situation pending on waiting list, the sanctions against Russia, but during previous presidency in the United States, we observe multiple sanctions imposed as secondary against the parties, against persons and companies in certain jurisdictions which circumvent United States sanctions. And OFAC is using very aggressive method even now, but only with regard to Iranian sanctions. So it follows all operations, all transactions, which involves US dollar, which involves global markets, supply of prohibited goods to prohibited actors, and any company, let's say even small one, even if you're a small, medium enterprise, you're not a giant legal tech company, you're not a giant exporter, even if you have 10 employees and still do business with risky jurisdictions, with jurisdictions which have many red flags, you might face secondary sanctions from the United States. And this story was not that much important for European Union until recently, because the European Union, in the same vein as the United States, introduced recently the mechanism of anti-circumvention, which actually now might invoke third parties practitioners, third parties companies be responsible for circumventing, for intentional circumvention, for non-intentional circumvention of European Union sanctions. And here is a very clear example I would like to highlight is recently European Union even targeted Chinese companies, Chinese banks. That's for a long time considered something unacceptable or a precedent that European Union is starting to target even, let's say, in such a fragile environment, Chinese companies and banks. That said, in all other jurisdictions, no one been shielded from sanctions circumvention and responsibility for violating sanctions regulations of the European Union. If DG FISMA, for instance, or financial department units in the member states find grounds for such violations to happen. And again, as practitioners in third countries, you have less access to judicial protection within European Union. So violating and being involved in circumvention schemes meaning that you cannot easily go to the court to claim that the violation didn't happen. One more example to show and to draw your attention to is the case with regard to recent sanctioning of the bank, of the second largest bank in Kyrgyzstan, which involved really high-level and very heated discussion and information exchange between Kyrgyz president and UK officials. That bank been targeted for aiding companies in Kyrgyzstan to help with evasion financial operations. So you can see that we go from small, medium enterprises, we go to second biggest bank in the country, and again, the risks are so high that I think nobody cannot longer ignore them. Then let's jump to the infrastructure itself. We see the reasons why we're here. We see that the environment is really problematic, especially for certain countries, as knowledge is sparse, as communication is unified, but the regulation different. And to follow the regulation from 3 jurisdictions, from United Kingdom, from United States, and European Union might sound easy, but in practice, it involves in-depth understanding of how the sanctions systems built and what principles they govern by. And here we need first to come with ideas that in the United States, there is no single sanctions authority. There are few of them which involved in the sanctions enforcement and implementation. And the most important one to start with is OFAC. So I would show very quick just how many sources one has to consider before going into trade operations. So financial operations involving some third party or risky jurisdictions. So we have, first of all, we have Office of Foreign Assets Control, which is the most active one, and it's always publish information about recent designations in the news. But the most problematic part from my side is that you actually can find here the designated person, you can find here the designated companies through their service, but then the problem comes with the persons who are under control, or companies who are under control. And you need to consider carefully that not only the persons mentioned in specifically designated list or other lists maintained by OFAC might be under sanctions, but also the companies under their control, the entities which has 50+% of shares in that company, and going into this kind of operations is kind of difficult because, for instance, if we take Russia, many registers, public registers, are closed, and just simply go and check in the official register whether a person in question holds the shares in the company is not that easy task. So sometimes you need to have additional access to the instruments which will allow you to do that and check whether the sanctioned person has further connections. Second is which I call BIS, is Bureau of Industry and Security, which maintains its own list of sanctions. And somebody considered that BIS maintains only sectoral sanctions, but this is not all true. We can say about it, because BIS, for instance, maintains the list of denied persons, arms list, which prohibits dual use, transfer of goods, and other lists necessary to take into account during the screening. And so if you look through sanctions list at OFAC, or if you look separately through sanctions list provided at BIS, you would find that then you need to use two lists. And here is very important tool that combines both lists in one place, because here you have only OFAC and here you have only BIS, which is provided by International Trade Administration. So here, if you look for a person or company, you will find the designated person or company from both lists maintained by OFAC, by BIS, and also by State Department, which is a third actor in United States sanctions. And I will share further the screens, but here just you can see how many actually sanctions lists are, and not always they designed in straightforward way. Of course, you can ignore military list, but sometimes you need to check whether the person in question with whom you want to deal with is mentioned in any of those lists, because there is now consultations that BIS, similarly to OFAC, might apply the rule of 50+ shareholders' rights. Then it will mean ownership rights. Then it will mean that you will go into more sophisticated screening. And I will share these things further, but again, it's a very good navigation if you firstly encounter US sanctions, or even secondly. What is the problem here is that some of sanctions imposed by United States, they not systematized in any way. That many sectoral sanctions are imposed through decisions of OFAC, but you would not find any list here with all sectoral decisions. So only way, let's say so, to be sure that you're not violating any sectoral program of OFAC is actually to go through all news pages, because usually it's the only place where OFAC publishes its sectoral designation, or how it's called, sectoral determination, at this news page. So you cannot just simplify that you have sectoral sanctions mentioned by BIS, but also you need to consider 3,000 results, and I think that probably 100 from these 3,000 results are about sectoral designations of OFAC. And if we go even further, some of sanctions imposed by OFAC, for instance, on tobacco sector of the economy in Belarus, you see that this is not sectoral prohibition per se, but it is a risk determination, which says that you're not prohibited to deal with tobacco sector in Belarus, but if you deal, the state secretary will consider you as a person in question, and further, the chances that you might be designated for dealing with tobacco industry in Belarus are higher several times than actually if you're not dealing with the sector. However, in certain cases, the prohibition is strict, and it's saying that you've completely been banned from dealing with a particular sector of economy. And again, both sectoral prohibitions you are to find in BIS and in OFAC web pages. Going further, and not again, you probably all know about FAQ section. I will not stop here, but it's important to consider. Going further, we have European Union sanctions, and we talked about why it's important to follow those sanctions because of anti-circumvention mechanism. I even can say that it is curious to see that Turkey regime is in place with regard to some drilling activities at EU sanctions map, but it's very symbolic. It has no real implications, I would say. And here you might find peculiar situations that, again, to understand the full complexity of sectoral sanctions imposed against Russia, you actually need to open the page about Ukraine, because some of sanctions imposed with a view of destabilization in certain areas in Ukraine. But then you need also go and check Russia sanctions webpage. And some sectoral sanctions imposed under the regulation where it's imposed due to acceleration and systematic repressions in Russia. So part of sectoral sanctions mentioned and listed in that regulation. But the biggest part of all sanctions imposed against Russia are mentioned in the regulation, which is which number has 833. So I mean, if you work quite often with sanctions, you probably remember this number 833 because it's too popular not to be ignored. And here you will find interesting situations that at some moments, and we have the situation with Belarus right now, EU imposed new sanctions, and those sanctions are to be mentioned in the consolidated data list. But the process of consolidation of information into one file takes enormous amount of time in European Union. So whenever you see that a new regulation appears here, exists here, you need to double check and not only cross check all current prohibitions with the consolidated regulation, but also start to consider the regulation which is not included in the consolidated regulation, meaning that it's double work. It's sometimes painful because sometimes the additional regulation, let's say, amends the consolidated regulation, and then you need to understand from the changes in the amendments what parts will be removed and what parts will be enforced and not in effect. And this is, let's say, not easy work. And for instance, in the last sanctions update against Russia in the regulation number 833, I found that at least for 2 months, the consolidated regulation was not updated. But when it was updated, I found additionally about 200 new HS codes. So if you deal with trade operations and if you do business day-to-day work, you know for sure that there are numbers of HS codes here, which says that you cannot export the item under this HS code to Russia or facilitate the transportation into Russia. And then you will find that in the amendment, there are plus 200 HS codes, up to 300 HS codes in the new sanctions package. And you need to comply with this 300 sanctions codes after the regulations comes into force. But again, then you required to look further and beyond the Consolidated Data Act. We're not going to stop here on the UK, as UK is pretty much the same as European Union in many regards. And here I would like to pass the floor to my colleague, Darya. She will tell more about the cases of due diligence and sanctions violations per se. And thank you for your attention.
Yeah, thank you. I saw that there were some questions about Bohdan's part. Maybe it makes sense to ask them right now or no.
We don't have any questions yet.
Oh, sorry. Then I just suggest that if you have any question during my presentation, don't hesitate to interrupt me and we can discuss this in the process. So Bohdan, could you share, please, the presentation? As I have already mentioned, we work on sanctions circumvention. We conduct investigations, and targets of our investigation are then subject to sanctions in Ukraine, United States, and European Union. And what we realized during this work is that sometimes companies don't know that they are involved in these sanction evasion schemes. And actually, they are quite simple steps that they can provide in their inner policies to enhance their compliance, and I'll be happy to share them with you. Next slide, please. So how to check that Russian companies have any connections to Russian military industrial complex? First of all, you can just Google and read investigations. I think that there are already a bunch of different media outlets and analytical centers, think tanks who conduct this investigation, and you'll probably easily find this information just by Googling. Then you can check sanction lists. There are websites like Open Sanctions and other websites that Bohdan have already shared with you, where you can check and figure out whether this company is already under sanctions. Third step is to review company websites. Sometimes you can find quite interesting information on them, because we found websites where they claim that they help to circumvent sanctions. So they even advertise their services as sanction circumvention services. So it should be red flag for you already in this step. And also, you can find information about owners of this company on their website, or about their customers. And again, sometimes among these companies, you can find companies linked to Russian military industrial complex. Also, it's good to try to figure out who are shareholders and directors of your customer. You can use for this purpose special registers, for example, like U-Control Board or North Data. But also, honestly speaking, majority of legal entity registers are publicly available, and you can even find official information about the shareholders and directors of the company just using these registers. And again, if you see that company in I don't know, in any jurisdiction, not Russia, is owned by Russian, and then you can Google these names and you'll probably find out that they also have some companies in Russia. I'll show you these examples just in a few slides later. Next two options are already more advanced, but still, if you want to enhance your due diligence, you can use it. You should analyze procurements in Russia. There are two main websites that collect information about procurements. It's Clear Spending and Decoupling. It could be slightly tricky because it's in Russian language, but you can use a translator like Google Translator app, which allows you to translate the web page and try to figure out if this company had any procurements with a Russian MOD or any companies related to military. And also try to assess their economic activities, because sometimes, and this is maybe the most trickiest one, company don't have any direct links with Russian military complex. They are like innocent intermediaries, and then you need really to conduct regular investigation to figure out that they are somehow connected to military. Next slide, please. Thank you. So right now, I want just to share some cases that we investigated to show you most popular sanction evasion schemes, so you could be familiar with them. This one is a typical scheme when Russian redirect goods that they need for military production. They buy it in Europe. They buy it from companies like from Turkey, Hong Kong, from Kazakhstan, and other countries from Europe, and then redirect these goods to Russia. And in this particular case, it's quite interesting because as intermediary, it was used Turkish company, and it was quite easy to figure out for European manufacturers that these Turkish companies is owned by Russian. It actually took only 1 minute for me to figure it out, because Turkish registry is publicly available, and if the compliance of this listed company in Czech Republic would have been better, they probably would not help Russia to buy these goods. And this is the first thing that you can do if you want to check. And in this particular case, a Russian who owned the company in Turkey, they also owned companies in Russia, and these companies advertise their services as sanctions or convention services. Next slide, please. This case is also a case when it could be easily checked, because red flag in this case was that company that was established in Turkey. It was established after full-scale war, and it is already suspicious because after full-scale war, this company helped Russian companies to buy raw materials in huge amounts, and they didn't have any operations before, and they started like from scratch, but already after full-scale war, they started selling big amounts of these raw materials, which is also suspicious. And when we started digging deeper, we realized that this is also a company that is not directly, but still owned by Russian. And probably it's subconsciously not obvious that Russia needs raw materials, because it's a big country and they have really huge territory, and they probably have all elements of periodic periodic table and they probably can mine all of them. But the thing is that it doesn't make any sense in terms of revenue because they don't have a big inner demand, and they should then export these raw materials. But this market is already owned by China, because China usually sell these raw materials for this better price, and that's why Russian really lack raw materials for their production facilities. In this case, our investigation showed how they used then these raw materials to produce missiles, what cycles should be done. And unfortunately, some other countries are also involved in the sanctions circumvention schemes. They probably don't realize even that these raw materials could be used for weapon production. Next slide. This is also a quite interesting case study, because in Russia is big, I would even say huge holding. It's Rostech. It was established in 2007, and it has right now more than hundreds and thousands companies, and no one knows the real number of these companies, and no one has list of these companies. And it brings together enterprises across key sectors, including aviation, electronics, medicines, and other mechanical engineering companies. And all these sectors are needed to provide the Russian military enterprise complex with the goods that they need. And according to Ukrainian military intelligence, this corporation Rostech is responsible for over half of Russian total weapons and military equipment production. And here is the thing. So some companies of this holding produce weapons. And here's easy. You can check and figure out that this company is related to military. But as I have already mentioned, some companies produce medicine or other civilians goods. And at first look, you can think that it is just simple civilian company and sell them some goods. But then this, let's call them innocent entities, resell these goods to military companies of this holding. So it's also could be a red flag for you if you have found that your customer is one of the Rostech holding company, and even if it produces some civil goods, it still doesn't mean that your production won't happen then in Russian weapon. Next slide, please. This is also already one of the advanced case, I would say, but still I'm happy to share it. It's about Finnish company, Campi, who produce CNC machines and machinery in general, and Russia like these technologies a lot. Honestly speaking, every single military industrial complex, if it's modern one, needs this machinery to produce weapons. And Russian rely on Western CNC machines. So they try to buy it even under sanctions. They try to build new supply chains because it's really vital for them. And in this case, we found out that one of Russian companies that is like logistic operator or something like that, sell this CNC machines from Finnish companies to Russian military industrial complex. But before we found these documents, it was quite suspicious because this Finnish company sold to this, let's say again, innocent intermediary that do just logistics. And when we tried to figure out who are shareholders and directors, we found out that this two women who have quite simple life. They don't look like businessmen who have big turnover. And we realized that it's probably just frontmen and they don't have any understanding what this company is doing. They were just used to register this legal entity, and that's all. And this also could be a clue for you if you see that sometimes the owners of the company don't look like they could be real owner. Probably they are frontmen, and you should dig deeper. And then finally, you'll find that they are some Russian who are linked to military. Next slide, please. This is one of the instruments that you can use. This is website that is called War and Sanction. It is held by Ukrainian Defense Intelligence. They verify all information that is then published on this website. So there are different databases there. For example, you can find information about Western components, and not only Western, but different components that were found in Russian weapons. You can find also technologies that Russia lacks and needs to produce weaponry. And what is good that this database is updated on regular basis, and you can easily find any information like that about weaponry that was used by Russian, like in July or August, for example. And there are also different types of information. Sometimes on this components, you can also find number of this component, which allows then manufacturer to identify who was their customer who bought this components, and to figure out the whole supply chain and how it went to Russia finally. So if you hesitate in whether your components could be used in weaponry, you can go to this website if you have some electronics company, let's imagine, and then try to filter data by the name of your component, and maybe you'll find that these components are widely used in Russian weapons. Next slide. This is example of our case study. A year ago, we launched our big report about FPV drones manufacturer. As you probably know, FPV drones is a major game changer on battlefield in Russian-Ukrainian war, and we conducted investigation and figure out which companies from Russia are involved in production of FPV drones. We also analyzed their import data, their shareholders, and finally, some of these companies were added to the website, War and Sanctions. So it's again could be sign for you if you find this company on this like company that you want to sell some goods on this website. It's a sign for you that it's deeply involved in Russian military. And next slide, please. So to sum up, how you can ensure that goods are not used in war. First of all, you can refer to common high priority item lists. It was published by European unions and it has like 50 HS codes. And if your goods are described in this list, you can be sure that it will be finally used in Russian weaponry. Read investigations. Many items are identified and analyzed there and published in reports, and it could be really handy for you. And again, this database, War and Sanctions, it's verified by Ukrainian Defense Intelligence. It's regularly updated, and you can rely on this information. And the last slide, please. So, which red flags you should consider during your due diligence process? If company have been registered recently, and especially if it started already with a big amount of other customers, it should be suspicious. Second one, it's lack of physical office. It could be also sign that it was just established like legal entity for redirection goods from Europe to Russia. And they honestly don't need this physical office because it's just one transition station on their way. If the address is shared with multiple other businesses, here you should pay attention to such details as phones number or emails, because you can easily check them, and sometimes you can find that they belong to Russian. If shareholding structure is complex, and if it includes so-called non-transparent jurisdictions, it also could be sign that someone want to hide that they own these companies, and probably they are involved in money laundering or in sanction evasion or any other illegal schemes. If you find out that one or other or some other people hold similar roles in numerous of other firms, it's barely possible, and probably they all are also just frontmans, and they don't work in these companies for real. If you find Russian government officials or former officials or their relatives as directors or shareholders, this is also a big red flag. If you can't find website of the company, it could be also quite suspicious, because usually people, when start their business, they want to advertise their services and they want to find more clients, and that's why they need some social media and websites. And if there are no contact points, it could be also one of the red flag and the sign that you should maybe conduct investigation and try to figure out who owned this company, when it was established, and so on. If in past the company dealt with Russian entities and linked, especially those that are linked to the military, because usually, it's not always, but usually they try to hide this information right now after full-scale invasion, You can easily find any information about their operation in the past, but not now, and it could be also a sign that this is not reliable company. And if you find evidence of microelectronics or other dual-use goods being shipped to Russia since February 2022, despite no prior history of such activity, I'll explain. Sometimes we find companies that sell cosmetics, for example, and then when we check Russian custom data, we see that they have export operation with Russia, and they sell CNC machines, for example. And this is quite obvious that even if this company sells cosmetics on their website, and at the same time they sell some sanctioned goods to Russia, that they are not reliable, and they also are used just like intermediaries. This is all from my side. If you have any question, I'll be happy to answer them. Thank you.
Thank you very much, Darya. It was very insightful and especially good alert for the companies doing or trying to do or thinking to do business with the Russian entities or the Russian linked entities or the transshipments. So I would like to turn back to Bohdan as he has some few words to say. Bohdan?
Yes. We want then to cover what can be helpful in terms of monitoring and what real-time instruments can be used to, let's say, avoid the risks or minimize them. For instance, Darya mentioned custom declarations, and I know that few services like Abrams or Import Genius providing a batch of custom declarations. Usually they do not cover like 100%, but I could estimate that the coverage is about like 20, 30, 40% of real operations, but it could, give you a hint where to look. So I will share one more time to show actually the platform which I created to help practitioners and to help business to do compliance check fast. And this is a free platform. Anybody can use it in any way. And of course, you can look for concrete companies or concrete entities here. So if you want to see Russian nuclear energy producers single provider, you can find that Rosatom, its affiliated companies, been sanctioned, but you will see that it's not Rosatom itself, it's its subsidiaries. Then the question is, how will you approach contacting and doing the business with Rosatom when you see that numerous of its subsidiaries are under sanction? So the advantage of this resource is that you can see the information not about names and a case devices, but also you can see the information mentioned in the reasons for sanctions imposition. And you see in the reasons of sanctions imposition that a certain company has been sanctioned because it is a subsidiary of Rosatom. Then it's a good question to your compliance officer, to your director of the company, whether you should deal or whether you should proceed with the transaction, or you should then consider certain unintended consequences of doing the business with subsidiaries, because otherwise I think the US administration might change the approach and then go further with more aggressive sanctions. And I assume it's only my thought that if Trump decides to push forward Russian sanctions once again, and he sees no further actions with Moscow, then I think the number of sanctions might be even doubled, because for sure OFAC has already collected many pending sanctions impositions during this hold situation. So I guess that it would be quite a lot of new sanctions if Trump decides to resume the application. Also, you can check if you deal in steel sector, or you sell timber, or you're involved in the timber area. You can check the companies, and you want only to check Russian companies. So you see actually that here we see only 2 companies in the timber sector, somehow related to the timber sector, but again, not a lot. And if you do a timber business, then you might better check other connected to Russia instances. But as I remember, the timber sector is under sanctions, sectoral sanctions, but not in Russia, in Belarus. So yes, if you do business in certain sectors and you want to check the partners from this sector through all sanctions information, you can do it right here. And you can limit the research you aim to. For instance, you do iron business, and again, you can select that you only want to see a company in iron business from Russia, and you see that United States designated 14 companies which has iron in their name, or iron in the reasons of sanctions, or iron as an official way of the business. I mean, the companies in the iron sector might be more, but still it's, let's say, a certain point from where you can start doing compliance research. And afterwards, you can click on the company and see the information about it, see all the relevant details, see the official reasoning, which is really important to understand the depth and the scope of the designation. And sometimes in the reasonings part, you might find additional information which will lead you that the company, for instance, this company might not be under sanctions, but this company controlled by the person who has been designated, which actually means that you cannot do business if you don't want to violate US sanctions with that company, because that person mentioned as a shareholder or as a owner of that enterprise. So it's very important always to check the reasons and to have the much information as possible. Secondly, what I would like to show you and describe that sanctions will be for a long period of time, as we can see from 2022, since the full-scale invasion of Ukraine, the number of sanctions, the number of designations are on rise, and every year we observe more and more designations from the United States, but the level of EU designations, for instance, is decently high, less related to UK, but still you see that the number is up to 1,500 designations, which in practice will lead that there is about 10K, 20K of more companies under sanctions because of the control rights, because of the ownership rights, shareholder rights, and so on. So usually you can multiply the number of designated persons 10 times just to understand how huge actually the area and sector is covered with. And one last thing I want to show you here, and which is still in the testing mode, but it will appear quite soon in the full mode. Now it has covered only Russia sanctions in full, but as we talked about custom codes, which is the key to understand what you can do and what you cannot do. I'm not talking about service sanctions, because it's other story when you're providing software services, when you're providing consultants and so on, banking service. So let's keep it aside and presume that the majority of you today doing business in trade sector, or trading the goods from Europe to other jurisdictions. And here you will find that, like, of course, Russia has been under the most severe sanction regime, but then you might be found by surprise again. Belarus sanctions are much more Belarus sanctions. It's only testing mode, but you can see that certain types of goods are prohibited to transfer to Russia and to Belarus as well. Certain types of goods prohibited to transport only to Russia. And yeah, we have, for instance, truffles. So if you have a Russian importing company asking you to purchase truffles and to export from, I don't know, from Italy, for instance, the truffles to Russia, you will find that the custom code, which mentioned truffles, is under sanctions. And if you do so, you likely and most likely, probably, you violate sectoral sanctions, because you're facilitating the export of prohibited goods from Europe to Russia. So then you might face, if member states decide so, or if FISMA finds the evidence, you might face not secondary sanctions, but instruments imposed through this anti-circumvention mechanism. So you might be also appeared on the sanction list if you do this type of business. And what Darya talked about is that we have also high priority list, which is, let's say, if you export, facilitate export of truffle, there might be consequences, but not for granted. But if the facilitations happens with respect to high priority goods, then consequences will be for sure, because certainly because this high priority list is closely monitored by EU institutions, by dual export institutions in the European Union, and any transshipment, any facilitations here, let's say, very, very likely probable will lead to anti-circumvention sanctions. So you should really keep eye on those goods, those items, and know them by heart in order to avoid severe consequences, legal consequences, which you might face if you find such type of violations happen. So yeah, this website is you to use. It's free of charge. You don't need to pay anything. You can just enter. You can understand the numbers. You can see that for instance, United States imposed 5,800 sanctions, OFAC sanctions against Russia. You can select and search through different filters. If you want Russia, the number expands to 7,000 sanctions, because 5,600 imposed by OFAC and additional number imposed by BIS or by the State Department. So then you have the whole picture and understand the numbers, actually, which is really critically important. And as well, you can select any other country you wish like to explore and do business with. Thank you so much.
Thanks, Bohdan.
Yeah,
there is one question about the methods to check the customs declaration and information. So the question is from Marina, and it says about the methods to check customs declaration and information about goods imported, exported by a company by HS. We should go to and check on Abrams and Genius websites. Did I understand well? And are there any other sources? Thank you. Extremely valuable webinar. Thank you all, she says.
Do you want to answer now or after your?
No. You can answer it now. Then I will take the.
So actually, the question of checking custom codes is a life story. It's never been stopped, and again, why? Because you have to observe and to see that the EU provides clearly custom codes under prohibition, but not always. So let's say 80% of sanctions related to goods are mentioned under HS codes or CN codes, SN, SN or SN codes. So they, let's say, more common to custom practitioners. You can find them in sanctions regulations, so in the consolidated acts, which I show you in the first section. Again, you need to see whether there are no amendments. The amendments might have 200 new custom codes under prohibition, like in the last regulation against Russia. And then in the United States, you need to double check because BIS, for instance, mentioned custom codes. But then if you go to OFAC sectoral determinations, no HS codes are mentioned. And it's only a question of your own internal intelligence, your own compliance analysis, whether, let's say, certain custom codes fall under sectoral determinations made by OFAC. So yeah, here you can more easily, let's say, so adjust these things, but when it goes to OFAC compliance, things become even more complicated.
Yeah, because the HS codes are not in compliant with the US system. That's another issue. So I will give some brief information about the Turkish perspective and what we do and how Turkey positions itself and the third countries G7 sanctions decoupling risk and streamlining the compliance. And in this session, I will focus on the interplay between G7 sanctions net enforcement, Turkey's strategic trade control framework, and practical compliance challenges companies face when operating across multiple jurisdictions. This will not be a political commentary, but rather than a legal and a regulatory analysis based on the current laws, international control regimes, and enforcement trends. So the G7 sanctions framework is designed to coordinate the policy across multiple jurisdictions. However, in recent years, we have seen increased sanctions decoupling, a divergence in how these jurisdictions define, apply, and enforce restrictions. For compliance officers, this means that an activity permissible under one national law might constitute a sanctions breach in another. For Turkey, which is not a G7 member, but a major trading hub between Europe, Asia, and the Middle East, this decoupling presents both operational and legal challenges. So what's sanctions decoupling? The sanctions decoupling occurs when sanctions regimes that are nominally aligned in purpose differ in scope, enforcement intensity, or listed targets. This is increasingly visible between the EU, US, and UK frameworks, particularly on Russia-related measures. While all three aim to restrict the transfer of sensitive goods and the technologies, their implementation timelines, licensing exemptions, and enforcement strategies are differing. For companies operating through Turkey, this creates a complex compliance environment, one where meeting the Turkish legal requirements under the Law 5201 and the control list does not automatically ensure the compliance with the US or the EU sanctions law. The third country risks, sorry for that. The third countries, those who are outside the sanctioning coalition, can become routes for sanctions circumvention. And the G7 has repeatedly warned about the transshipment through such jurisdictions, For example, the dual use failing under the Wassenaar arrangement or MTCR category 2 items may be legally exported from a G7 state to Turkey, but if those items are subsequently re-exported to a sanctioned jurisdiction without the necessary end user controls, that creates an exposure under both foreign sanctions law and the Turkish export control legislation. Especially Article 5 and Article 6 of the Law 5201 regulation makes clear that the export or the transfer to third countries require a Ministry of Defense license, and then end-use assurances must be verified. And what's going on? In the past 18 months, G7 enforcement bodies have significantly increased scrutiny on the third country intermediaries. As Bohdan mentioned, the U.S. Bureau of Industry, the BIS, has issued entity list designations for companies facilitating re-exports from Turkey, the United Arab Emirates, and Central Asia. The EU has adopted no Russia clauses in supply contracts to address rerouting risks. And from a Turkish perspective, these developments intersect with the national obligations under multilateral regimes, particularly Wassenaar's catch-all provisions, which require a denial of the exports if there is a knowledge or suspicions of WMD-related or military end use in a sanctioned jurisdictions. About the Turkey's legal framework, there is a law 5201, and according to the law, the production, import, and export of war weapons, vehicles, ammunition, and their parts require licensing from the Ministry of Defense. And the implementing regulation specifies the conditions for licensing, including the requirement for an end user certificate which aligns with the model forms agreed under the Wassenaar arrangement. Law No. 5202 governs the defense industry's development and cooperation agreements, giving the Presidency of Defense Industries authority to impose security and technology transfer conditions. The KTL 2023, which is a control list, it integrates the Wassenaar and the MTCR list into Turkish law, meaning that any item controlled under those regimes is subject to Turkish export licensing. And from the dual use and the munitions controls perspective, the Wassenaar munitions list covers military grade systems, while its dual use list regulates items with both civilian and the military applications, such as advanced electronics, sensors, and the navigation systems. The MTCR Annex in its 2024 update sets out the Category 1 and Category 2 items, with Category 1 including complete rocket and UAV systems above the 300 kilometers and 500 kilogram threshold. Even if a transaction is outside the normal scope of the formal scope of the Turkish sanctions measure, this control list creates a licensing obligation. And this is where the third country risks become acute, and an item may be lawfully exported from Turkey, but if it is onward transfer breaches another jurisdiction's sanctions, your company can be caught in cross-border enforcement. Regarding the case studies of the circumventions, and we consider let's consider a shipment of a UAV avionics which is controlled under MTCR category 2 item 11, which is exported from Turkey to a non-GE country under a valid 5201 license. If that country then re-exports the avionics to a sanctioned state, the Turkish exporter may face a foreign sanctions enforcement for contributing to the circumvention. Another example is high-precision bearings under the Wassenaar dual-use list exported to a regional distributor, which is later traced to missile technologies and the missile production in a sanctioned jurisdiction. These cases illustrate why exporters must assess not only the immediate transaction, but also the likely re-export the trajectory. A robust compliance framework in this environment means centralizing your screening process to apply the most restrictive applicable standards and to incorporate the G7 denied party list, Turkish control lists, and the contractually binding no re-export clauses into your supply agreements. To ensure that you need to be ensured that your internal procedures for 5201, 5202 licensing also capture foreign sanctions requirements, even when those are not binding under Turkish law, which is required to mitigate the enforcement risks. And related to the technology and the data, leveraging the technology is essential. And we suggest the companies to use automated tools for transaction monitoring and risk scoring for counterparties. It's essential also for flagging the high-risk commodities codes such as HS codes linked to WASENER or MTCR items or the BIS regulations. And to integrate the customs and the logistics data to detect the unusual routing, for example, the goods and the shipped to a small trading company in a third country with no legitimate end-use capacity. And there, oh my God, I have some troubles. And at the end of the day, the cooperation and the information sharing is also essential, and engaged proactively with the Turkish authorities, including the MOD and the Presidency of Defense Industry, when you suspect a potential diversion risk. And the participation in the public-private partnerships, including sector-specific compliance forums, can help align your internal procedures with evolving enforcement priorities. The G7 has emphasized cross-border cooperation, and the Turkish companies benefit from demonstrating a proactive compliance posture. In summary, the sanctions decoupling is not merely a political term, and it's a compliance reality. And for exporters and internationally, for intermediaries operating from Turkey, understanding and integrating both domestic and strategic trade control obligations and the foreign sanctions requirements are essential. So the legal frameworks of the Turkish law and the multilateral regimes like WASENER, BIS, MTCR already provides the structured tools. The challenge and the opportunity lies in applying them with the foresight, aligning your compliance program not just to the law as written, but to the law as enforced across the jurisdictions. So we always suggest the companies to be cooperative, to adopt their tools and screening, and to share all the information with the authorities when it is essential. And thank you very much for listening to us. And if there is any question, we will be glad to answer them all. Yeah, a little out of time. No questions?
And if I may ask you, as who deals with sanctions every day, what do you find the most challenging request? So how it looks for you? What problems you face usually during compliance? Lack of information, lack of knowledge, lack of systemized database or AI tools. Please share your thoughts.
Sure. As a legal practitioner, we advise the companies doing business with Russia in the non-sanctioned areas. And in the compliance procedures and the controls, we regularly being asked that we ask the companies to send the Know Your Customer forms to us, and we make a search on that. But in the Know Your Customers, we see that there are lots of lacks of information. The Russian entities do not provide the sufficient information, and they do not provide the shareholding and the controlling status of the company. On the other end, there are some entities who are listed, wants to be delisted from the European or the US lists. And when we advise them from the legal perspective, they mostly apply to choose to set up a new entity and to proceed their business from the stage that they left. So they do not want to be delisted, but they again want to circumvent the sanctions by changing the status of their company. So these two are the most challenging issues that we are facing in our daily practice. If there is no questions, then I would like to thank to everyone who joined us and especially our distinguished speakers. We hope that we will be together soon and contribute more to the sanctions and the export control community. And thank you, Bohdan. Thank you, Darya. It was a very productive and insightful talk and a discussion with you. Please get in touch with us if you have any further queries, and we will be responding to you as long as we can do that, because the sanctions issue is a very sensitive issue. There is a comment. Thank you very much for this webinar. Extremely insightful. Thank you very much, Marina. And thank you for everyone for joining today. And we look forward to seeing you in other meetings and the discussions. Thank you.
Thank you for organizing it.
Thank you very much for having us today. Bye. Have a nice